Hi, everyone. Welcome to today's webinar. We're going to wait a minute because apparently it takes Zoom a while to let everybody filter in. So I think that's going to take about 30 seconds and then we will jump right into it. It looks like we might have people from around the world, so that's exciting for us. So hopefully everybody is able to make it here in spite of all the time zone changes. So we'll wait about another 10 seconds and then we will jump right in. Excuse me.
I can see that participant number climbing, Phil.
It's great. Okay, so I think now most people will have been able to join us through the Zoom slow filter process. So welcome to today's webinar. We're excited to have everybody here. This is the first in our series of monthly webinars discussing everything you want to know about trademark law and practice in Canada. If you are expecting a long, tedious webinar where the practitioners drone on and on about dull topics you care nothing about, if that's what you're expecting, you will be very disappointed. Today's webinar will be short and to the point, and then we'll stop talking. We'll only be talking for about 30 minutes. At the end, of course, we will be able to answer all of your questions. So today we will be discussing both surprising and challenging issues that you can expect to encounter if you designate Canada in your Madrid Protocol applications. For today's webinar, there will be two presenters. First, I would like to introduce my co-presenter, Jamie Lynn Kraft. Jamie Lynn is a senior associate here in the Ottawa office of Smart & Biggar. Jamie Lynn handles all areas of trademark law and practice, as well as marketing and advertising law. I am Philip Lappin. I'm a partner also at the Ottawa office, and I also handle all areas of trademark law and practice with a particular focus on oppositions, cancellation proceedings, and trademark prosecution. As I mentioned, there will be time at the end of the presentation for all of your questions, but don't wait until the end to ask your questions. Ask your questions at any time. To ask questions, write your questions in the Q&A box. So at the bottom of the Zoom window, you should see a number of tabs. So the Q&A tab is where you should write your questions. You'll also note that there's a chat box. Please don't ask any questions for the presenters in the chat box. Ask them in the Q&A box. So for those of you watching, you're probably familiar with Smart & Biggar. We're the largest IP boutique in Canada. We have over 100 lawyers, trademark attorneys, patent attorneys. We handle all areas of intellectual property, patents, trademarks, copyright, litigation, anything related to IP we handle, and we're happy to answer any questions about anything IP related. So here is a list of the topics we're going to cover today. So first, we're going to talk about correspondence. Now, this might not sound like a sexy topic, but in Canada, correspondence is very sexy, and you will see why. Then we'll talk about provisional refusals. In Canada, they can be very confusing, and we will show you an example. Then we'll talk about a type of objection that is new to Canada, and we'll explain why it's problematic. Then we will talk about what is probably the most reviled objection you can expect to receive from the Canadian Trademarks Office. We'll spend a short amount of time talking about final refusals and then divisional applications, which are new to Canada. And finally, and unfortunately, you cannot talk about Canadian prosecution without talking about examination delays. So stay tuned for that. So to start, if you have filed in Canada through Madrid and you've designated Canada, and if you are the foreign representative, you will unfortunately have received this very unfriendly letter from the Trademarks Office. Now, you might not be able to read this slide very well, so I'll tell you what this letter says. This letter says, you, foreign representative, are receiving this letter, and this is the only correspondence you will ever receive from us for the life of your application. I believe Canada is one of only a couple of countries in the world that refuses to correspond with foreign representatives. So who will the Canadian Trademarks Office correspond with? Well, the Canadian office is always happy to write to the applicant. And so the default is they will send all correspondence to the applicant. If you or the applicant do not want the applicant to receive correspondence directly from the Trademarks Office, then it is important to appoint a Canadian agent. This chart does show you, though, who the Canadian office will write to if there's no Canadian agent. So WIPO will post the first provisional refusal from the Trademarks Office. So we call this an examiner's report. So that will be on the WIPO website. But importantly, it's important to understand that any subsequent examiner's reports or office actions will not be posted on the WIPO website, and notices of default will not be posted on the WIPO website. What this means is that there are important deadlines that will not appear on the WIPO website. So it's important to understand that you cannot closely monitor what's going on in Canada simply by looking at the WIPO website. So you've received your first provisional refusal, and chances are you're going to be scratching your head. So on this slide and the next slide, we've reproduced a single provisional refusal. And this gives you an example of how confusing they can be. So I'm not sure if you can see my cursor here, but if you can see that on the lower portion of the first page, the Trademarks Office has cited about 10 sections of the Trademarks Act. This provisional refusal goes on for 4 pages. It looks like the office has raised some very serious and substantive objections. But this provisional refusal, and I'll show you the other 2 pages in a second, only raises 2 objections. In fact, one of the issues is not even an objection. They've asked if the mark can be translated. And then they've asked if 2 small descriptions of services can be further specified. And that's it. So 2 very small minor objections. And yet this provisional refusal goes on for 4 pages. So not surprisingly, we have many clients asking us, what does this mean? What do we have to do? And unfortunately, these provisional refusals do tend to confuse many applicants. So beware of that. Inherent distinctiveness. Now, this is a concept that many of you around the world are familiar with, because many trademark offices around the world will raise an objection that marks in certain cases lack inherent distinctiveness. But this is new to Canada. As you may know, Canadian trademark law was overhauled in mid-2019. And before that time, the Trademarks Office could not object that a mark lacked inherent distinctiveness. So this objection is new. But there have been 2 important factors since then. So first, Canadian examination is very slow, as Jamie Lynn will explain. And as well, the Trademarks Office has been carrying on a hiring blitz in the last few years. What this means is that there are many inexperienced examiners, and because examination is so slow, we have no case law yet helping anybody, the Trademarks Office or the practitioners, understand what this concept means. As a result, examination at the Trademarks Office generally, and also relating specifically to this objection, is uneven. The Trademarks Office is working hard to improve quality at the Trademarks Office, but they acknowledge they are not where they want to be. So as a result, we're seeing many objections relating to inherent distinctiveness that are somewhat questionable. But there are certain cases where you can legitimately expect the Trademarks Office to object that your mark lacks inherent distinctiveness. Let's look at a few of them. So if your mark is the name of a place, there's a very high likelihood the office will complain that your mark lacks inherent distinctiveness. If your trademark is an image, where the image is a drawing or a picture of what you're selling or relates to the services that you're providing, there's a good chance you'll see this objection. If your trademark is the name of a color that's common for the goods you're selling, so for example, white for paper, you can expect to see a complaint from the Trademarks Office. If your trademark is a single letter, or if it's a number, the Trademarks Office is almost certain to say your mark lacks inherent distinctiveness. And if your mark is laudatory, so in other words, if it presents praise, so wonderful or world's best, Trademarks Office is likely to complain. And here are 3 other examples where you're likely to see this objection. If your mark is a surname, very strong likelihood the Trademarks Office will say your mark lacks inherent distinctiveness. And if your mark is clearly descriptive. Finally, if your mark is non-traditional, and it depends the type of non-traditional mark, But for most non-traditional marks, you can expect this objection. So for example, if your mark is the shape of the goods, if it's sound, if it's color per se, taste, scent, texture, you can expect to see this objection. But certainly with respect to non-traditional marks, where offices around the world have this objection, you will be familiar with this objection for that for those types of marks. So what do you do if you receive an objection that your mark lacks inherent distinctiveness? Well, you have two options. So as I just said, unfortunately, quality at the Trademarks Office now is a bit uneven. They're working hard to change that, but it's uneven. So what this means is we're seeing a lot of questionable objections that marks lack inherent distinctiveness. And what this means is you should always consider if it's worthwhile trying to argue against the objection. And the argument would be maybe an acknowledgement that while the mark is weak, it does have some inherent distinctiveness. In other words, it can still function as a trademark. So it can act as an indicator of source, even though it's weak. So that's one argument. And in some cases that will succeed. However, if you've decided that the argument won't succeed, in other words, if you're willing to concede that your mark lacks inherent distinctiveness, there's another option. And the other option is filing evidence of what we call distinctiveness, or what most of the rest of the world calls secondary mutation. In other words, that a significant percentage of the Canadian target market has been exposed to the mark. There's a good chance that you can overcome the objection. So a couple of points to keep in mind. The evidence must be in the form of an affidavit, number one. Number two, the evidence has to speak as of the Canadian filing date. So any evidence that is subsequent to the Canadian filing date will be considered irrelevant and will be ignored. And finally, as some of you may know, Canada is divided into 10 provinces and 3 territories. Ideally, your evidence will set out the reputation by province and territory. So for example, let's say your evidence only proves secondary meaning in 2 Canadian provinces, then your registration will be limited to those 2 provinces. And now I will turn the floor over to Jamie Lynn, who will tell you about what is probably the most reviled objection that you can expect to receive from the Canadian Trademarks Office. Go ahead, Jamie Lynn.
Thank you, Philip. So yes, our next topic is CIPO's specificity requirement for goods and services. And anyone who has filed and prosecuted applications in Canada knows that the Canadian office has some of the strictest requirements in the world when it comes to identifying goods and services. Certainly more strict than the United States and Europe and other jurisdictions. And just because a particular good or service is listed in WIPO's Madrid Goods and Services Manager, that does not necessarily mean it's going to be acceptable in Canada. To give you an example, it's not enough to say clothing. You have to describe the type of clothing, such as casual or formal, or identify the specific item, shirts, ties, socks, etc. Because of these requirements, some applicants will seek to narrow their description before filing to preempt any objection. And while there are some benefits to that strategy, it also has some downsides. On the one hand, the final decision of whether a particular description is acceptable or not is often at the discretion of the examiner assigned to the application. So if you narrow your description before filing or designating, you might have done so without needing to, and therefore might have unnecessarily limited the scope of your application. So there's a benefit to filing with the description you want, which might be overbroad, it probably is, and then narrowing only upon receipt of the objection. On the other hand, just 2 weeks ago, CIPO announced that it would begin fast-tracking applications which list only goods and services selected from this pre-approved list, which is the Canadian Goods and Services Manual. So if there's a desire to move an application to registration sooner, then being proactively specific could actually pay off. But the Goods and Services Manual in Canada is not perfect. It's outdated, and applicants frequently find that they're not able to identify suitable entries to describe their goods and services. The good news is that CIPO has also recently announced that it will gradually be expanding the number of entries in the manual, beginning with the top 10 NICE classes filed within the last 10 years. Approximately 100 entries will be added to the manual each week in both French and English. So this means that you might be able to both fast track your application while also listing the goods and services you want. So although this is a frustrating objection at times, I think that there is light on the horizon here. Moving on to our next topic, the feared final refusal. So just to give you some background, up until very recently, SIPO essentially had an unwritten practice of not issuing final refusals, even though it had the power to do so. Rather, in the face of even the most hopeless substantive objections, you could continue filing arguments and evidence, and the office would keep responding with its own arguments. Applications could languish for years in examination this way. Most applicants would simply give up after a while, and those applications would go abandoned rather than being refused. If you wanted a refusal for whatever reason, you typically had to ask for it. Now, just 2 weeks ago, SIPO issued a practice notice advising that it will begin reducing the number of examiners' reports issued and, where reasonable, refusing applications. So this is all in furtherance of the goal to speed up examination times, which Philip alluded to earlier and which I'm going to talk about in a few more slides. The practice notice advises that examiners will only be required to address a particular argument once. What does that mean? Well, they provide some examples. Let's say you had a confusion objection and you responded by filing state of the register evidence to show the weakness of the cited mark. If the examiner is not convinced by your evidence, they'll issue a further examiner's report maintaining the objection with an explanation as to why the evidence was not satisfactory. If you then respond to that further examiner's report with even more state of the register evidence, and that still doesn't persuade the examiner, then the examiner does not need to issue a further report. Instead, the application could simply be refused at that point, and the reasons would be outlined in the refusal. Once an application is refused, the only recourse is for the applicant to file an appeal with the federal court within 2 months. At the moment, because refusals have been so rare, appeals from decisions of the Trademarks Office during examination are also quite rare. It's going to be interesting to see if these appeals increase under the new practice. But from a practical perspective, the takeaway is that applicants should consider putting their best foot forward in their first response or risk having their application refused. This could definitely impact some prosecution strategies going forward. So turning now to a topic that's not particularly unique to Canada, but is new as a result of our law change in 2019, which Philip mentioned earlier, that is divisional applications. Applications in Canada can be divided, and this includes Madrid Protocol applications. Why would you want to divide an application? Well, it can be a useful prosecution strategy, particularly given what we just discussed moments ago about final refusals. So, for example, if you're facing a descriptiveness objection, which relates to only a subset of the goods and services in your application, then you can divide out the unaffected goods or services and allow the divisional to proceed through to approval while you deal with the remaining issues affecting the parent application. So if you've reached the point in the prosecution where the examiner has raised the objection, you argued, they've maintained the objection, you might want to divide the application at that time to spare the unaffected goods and services from that final refusal, which could be forthcoming. Applications can also be divided after they've been approved. If, for example, an opposition relates to only a subset of the goods and services, you can see if the opponent would be willing to withdraw the opposition to the unaffected ones if you were to divide them out of the application. This way, you can get your registration for at least some of the goods and services while you battle over the ones in dispute. Yes, turning now to a topic that is unfortunately very Canadian, the examination delays at the Trademarks Office. I'll start off with a little bit of background. About 5 years ago, the time between filing and first action from the Trademarks Office was around 12 months. Examination times have steadily crept up over the following years, first to 18 months and then 24 months. And now the sad state of affairs is that examination times are sitting at around 30 months for direct Canadian filings. So the ballooning delays are a result of a perfect storm of factors, including the change to Canada's trademark law in 2019, which required CIPO to divert examination resources elsewhere, the accession to the Madrid Protocol, which resulted in a large influx of Canadian designations, and the pandemic, which ground much of CIPO's work almost to a halt for quite a few months last year. Of course, if the office is going to object to a Madrid Protocol application, it must do so within 18 months of receiving the designation. So Madrid Protocol applications will typically be examined earlier than direct filings. However, Madrid applicants should expect that examination in Canada is likely to take the maximum amount of time, that 18 months. There is a bright spot on the horizon. It's not all doom and gloom. The office has stated its commitment to reducing these examination delays. It knows this is unacceptable, and it's actively working to get that time down. Just 2 weeks ago, it published a practice notice setting out its initiatives to ensure the timely issuance of rights. We talked about some of these already. Fast-tracking applications which list only goods and services from the manual, expanding the goods and services in the manual, and beginning to issue final refusals so examiners have to spend less time on a particular application. Other initiatives include hiring and training more staff, not providing suggestions of acceptable goods and services in first examiner's report. So you might have seen if you filed an application in Canada, you receive your provisional refusal or your examiner's report, and there's a specificity objection. They'll say, okay, well, you can't have clothing, but it would be acceptable to say casual clothing, shirts and t-shirts. Well, you're not going to get those suggestions anymore. This apparently takes the examiners a lot of time, and instead they're simply going to say, these goods and services are overly broad, not sufficiently specific in ordinary commercial terms, and then leave it to you to figure out how you need to amend them. In future reports, if you haven't amended properly, then the examiner might provide examples at that time. And finally, and perhaps most excitingly, they're going to consider requests for expedited examination. And this topic is so exciting that I've devoted an entire slide to it. So there's some history here. For about the last 15 years, CIPO would not entertain requests for expedited examination based on the principle that examining an application out of order creates a favored position at the expense of other applicants. And you know that makes sense. However, given the current examination delays, it takes forever to get your mark examined, and that could have negative consequences on getting your rights and protecting your rights in Canada. So CIPO acknowledges this, and they will now begin accepting requests for expedited examination of applications in specific circumstances. So these circumstances are outlined on the screen. First, where there is a court action expected or underway in Canada with respect to the trademark, which is the subject of the application. 2, where the applicant is in the process of combating counterfeit products at the Canadian border with respect to the trademark, that's the subject of the application. 3, where the applicant requires registration of its trademark in order to protect its IP rights from being severely disadvantaged on online marketplaces. Or 4, where the applicant requires registration of its trademark in order to preserve its claimed priority within a defined deadline and following a request by a foreign intellectual property office. So the first 3 are actually quite broad, and I think that's notable. What does it mean, for example, when a court action is expected? How imminent does that action need to be? And does the applicant need to be the one asserting their trademark rights, or could it be a defendant? That's not very clear, and we really don't know yet under what circumstances the request will be accepted. The fourth criterion is a little odd, the one relating to requests from a foreign IPO. It's unusual, and we weren't, to be honest, when I first read it, I had no idea what it meant. And so with the further discussions with representatives of the Trademarks Office, we understand that this is a situation that might come up in very small, very specific situations in some foreign jurisdictions. So not sure how often that excuse is going to be used. And finally, in a separate and earlier practice notice, which issued late last year, CIPO announced that it will also entertain requests for expedited examination where the goods and services relate to the prevention or treatment of COVID-19. So again, that's a very specific circumstance. There's no fee associated with the request for expedited examination, but the request must be accompanied by an affidavit or statutory declaration setting out how one or more of the criteria are met. If granted, the office will examine the application as soon as possible. Not quite sure how fast that would be, but I'm told that back in the day when they used to consider requests for expedited examination, you received your examination quite quickly after the request was granted. So while it remains to be seen how CIPA will apply this new practice, overall, it's certainly a positive development for those seeking registrations in Canada. Ooh. Went one slide too far. I'm wondering if I can back up. There. Pardon me. So this brings me to our top tips when designating Canada in your international registrations. 1, designate early because it's going to take a while for the application to be examined. 2, appoint a Canadian trademark agent after you've designated so that you stay informed of all developments relating to the application. 3, be prepared to establish inherent or acquired distinctiveness because the Canadian office is very active with objections of that nature. 4, file comprehensive arguments in response to substantive objections to mitigate the risk of final refusal. And 5, consider whether the application is eligible for expedited examination in order to move to registration sooner. And as promised, I'm finishing up before the half-an-hour mark, and I'm going to open things up to questions. Do we have any questions, Philip?
Thanks, Jamie Lynn. So one of the challenges with Zoom is Jamie Lynn and I are sharing our screens. And so normally I would be very prepared, having looked at the questions and organized them. But every time I touch my screen, Jamie Lynn has a huge delay in changing the slides. So I wasn't checking out the questions. So we will now look at the questions. So first question, I would like to receive your slides. Will you provide? So after this presentation, everybody should receive a copy of our slides from the firm. If you do not receive those slides, feel free to send an indignant email either to the address you have for the firm or Jamie Lynn or me. We're happy then to forward the slides which you should have received. Here's another question. Are interactions with the Trademarks Office on distinctiveness all written, or is there the possibility of a hearing? And is there any appeal from the examiner's decision? So any formal communication with the Trademarks Office has to be in writing. So they're not going to make a decision based upon any communication that's not in writing. But you're always entitled to talk to the examiner, and you can also talk to the examiner's supervisor, and you can talk to other senior people at the office if you feel it's warranted. So the office is very open to communication, but ultimately after the communication, and typically if you have a discussion with someone at the office, they're not going to give you a decision. They can give you a sense of which way they're leaning, but they're not going to give you a decision. You have to put any response in writing, and only then will they formally tell you what their decision is. So is there an appeal from an examiner's decision? So this is a good question. So yes, there's always an appeal. So anytime it has to be a final decision. So they would have to reject your application. At that point, you have 2 months, and then you can appeal to the federal court. Now, traditionally, appeals have been exceptionally rare. They might happen once every 20 years, very rare. But as Jamie Lynn explained, the office has threatened to start refusing some applications. Once that happens, we're expecting to see more appeals. And in fact, we welcome appeals because there are traditionally no appeals, the Trademarks Office really is its own master. We think it might be good to have some more oversight from the federal court in terms of the kinds of decisions the Trademarks Office is making. And in fact, we've even heard the Trademarks Office at some point say they welcome input from the federal court to help guide them. So we're looking forward to more court decisions. Here's the next question. This one is for Jamie Lynn. You mentioned that applications which list only goods and services from the manual will be fast-tracked. First, how much faster will these applications be examined? And second, what if you file broadly, but then amend your application to include only goods and services from the manual? Will those also be examined more quickly?
Thank you. Okay, good question. We don't know how much faster. I think apparently examiners spend a good deal of time having to validate the goods and services. So hopefully it makes it much quicker, but they haven't given us a timeline of how much quicker that's going to be. And as for the second part of the question, let's say you file broadly, you haven't received your examination yet, and at that point you decide to amend your application to be more specific, such that each of your goods and services comes from the manual. If you do it at that point, then yes, you can be eligible for the fast tracking at that point.
Okay, thanks, Jamie Lynn. It's kind of a related question relating to specifications of goods and services. With regard to limited/specific lists of goods and services provided by CIPO, how do you manage the limited list of goods and services if using CIPO as your office of origin for a Madrid application, such that you won't be stuck with this limited list of goods when you go into your international registration?
Oh, that's that is a tough substantive issue, and it's something that Canadian applicants really need to think carefully about to decide if international registration is right for them, considering that limitation at the Canadian office. Because of course, if the home application on which the international registration is based is limited, then the IR has to be limited accordingly, and then all the rights are limited as well. So, if you have a particular good or service where you're going to have to be very specific, and that might not be might be ideal for describing your rights, then maybe an IR is not the way to go. It's really an important strategy discussion to have with your agent. There might be some cases where it doesn't matter. Let's say you sell wine and all you sell is wine. Wine is in the goods and services manual. Your Canadian application can say wine. You can use that as your basis for your IR, and it's not really going to affect your rights anywhere else.
Okay, thanks, Jamie Lynn. So here's another question relating to specificity.
Oh, hot topic.
Given how narrow Canadian specifications are by other jurisdiction standards, and that this spills over into Madrid Protocol marks based on Canadian marks, are you seeing much interest from Canadian applicants in using the Madrid Protocol for outgoing filings, or is it mostly inbound you are seeing the system in use?
So I think that's very much related to the last question, or perhaps I answered both questions with my last answer. What are we seeing? International registration for Canadians, it's there's a lot of factors that need to be taken into consideration. How many international jurisdictions are you going to go into? If it's not very many, then maybe the IR is not worth it. So I think that the narrow specificity requirements in Canada is certainly one factor which could deter using the international system, but it's certainly not the only factor.
Okay, thanks, Jamie Lynn. So here's a question. It looks like it's probably directed to me. When should one appoint Canadian counsel? At the time the Madrid application is filed, or once we receive the IR number from WIPO? So we get this question a lot, actually. Once a Madrid application is filed, there's a delay before you get your international registration. You won't be able to appoint a Canadian agent until the international registration number is granted. So you're going to have to wait until the international registration number is granted. Here's a question. I think this is directed to me. Will I be able to see refusals, etc., on the CIPO website? So could I check out the outgoing action about my designated registration there? So the question is yes and no. So The IT system at the Trademarks Office is a bit out of date. So if you look on the CIPO database, you can see a list of actions that have happened, but you cannot see any correspondence. So if what we call an examiner's report, or in the Madrid case, a provisional refusal, has been issued, you'll see it on the CIPO database that something is issued, but you won't know what's in it. You cannot access any documents online. You can order them from CIPO, but you need an account with CIPO and you need to pay through CIPO. So it's complicated to see it there. But if you want to get the file history from CIPO, you certainly can. Here's a question about appeals. How long does an appeal take at court? So it depends on the kind of appeal, of course. And as I said, almost nobody ever appeals a decision from the Trademarks Office. So how long would it take? Well, there'd be no evidence. So it'd be a purely legal argument in most cases. I guess there could be evidence, it'd be unlikely. So I'm not a litigator, I'm not sure, but I suspect you could probably have the proceeding go from start to end in about a year. Jamie Lynn, do you have any insight?
I think that sounds about right to me, but again, I don't know for sure.
So Jamie Lynn, here's a question directed to you. If you file a divisional application and you manage to register the refused goods/services after the registration of the divisional, can you merge them after, or will you have two registrations then to renew?
Yes, they can. A divided application can be merged.
Okay. Here's an expedited examination question. So this is also directed to you, Jamie Lynn.
Okay.
The third point in the expedited examination delay slide, if a third party sets up its own website selling products with your mark, but not officially selling in online marketplaces, will the applicant be qualified to file a request for expedited examination?
You know what? It's a good question. And I think that that situation could also conceivably fall under the first point, which was if a court action is expected or underway. I mean, what is an online marketplace? Is it just Amazon or eBay, or is it or is it anything which is being sold in the online space and online marketplace? I think it's the practice notice is quite broadly worded, and I think will be an opportunity to make some interesting arguments. Whether those arguments are going to be accepted is something that remains to be seen.
Okay, thanks, Jamie Lynn. Here's an interesting question. How strict is CIPO with overcoming the inherent distinctiveness objection? Have you seen any be overturned since the change in the law? So as I mentioned, quality of examination is very inconsistent. We have seen crazy examinations, objections based on inherent distinctiveness. At the beginning, so when our law changed in mid-2019, well over, this is my own anecdotal perception, but well over 50% of applications saw this objection. It was outrageous. The profession in Canada was in an uproar, and the Trademarks Office was inundated with complaints. So yes, many objections based on a lack of inherent distinctiveness have been overturned. In terms of how strict they are, they're very strict if they think the mark lacks inherent distinctiveness. And so like in many big organizations, or pretty much any big organization, there's a hierarchy. And so examiners typically, as long as they're not entirely new examiners, are entitled to make their own decisions. So they will decide whether or not they should issue an examiner's report with this objection. If it comes back, then often the examiner will consult with a senior person, and the senior person might decide that the objection was not warranted. So in terms of how strict they are, they have a set of criteria. If your mark falls within their criteria that they think supports the argument, they're going to maintain it. But if it's a borderline case and you can convince them that the mark has some ability to distinguish over other parties' goods and services, then they withdraw it. So it really depends whether or not you fall within the criteria. So if your mark falls within one of the list of types of marks that I set out on my slides, you will not be able to overcome that objection, except in rare cases. So for example, I mentioned that if your mark is a place name, you will receive this objection. If the mark is only a place name, you're not going to be able to overcome it. However, if your mark is a place name, but also has a dictionary definition, so it has two meanings, then you should be able to overcome it. So it depends on the context, but in general, the office is quite strict if they decide your mark falls within their criteria. And here's a good question. I don't know who this is directed to, so maybe I'll take it. It's, will the class in which the mark is put, according to NICE, affect the scope of goods and services for which the mark is registered? So this is actually a bit of a complicated question and can be interpreted several ways. So your scope of protection is typically who you can successfully sue. So class is ignored in terms of confusion. So classification is new to Canada. That was part of our overhaul of the trademark law in 2019. It's merely to help organize files, and it generates revenue. It has no substantive implication whatsoever. So class should be completely ignored in assessing confusion. So the Trademarks Office or a court will ask if a consumer sees one mark in association with certain goods and services, and then they see another mark in association with other goods and services, is the consumer going to think that both parties' goods and services come from one source or two sources? And if the Trademarks Office or court decides that consumers are going to think that all the goods come from one source, then they're confusing. But classification is irrelevant in determining confusion. Okay, I will direct this one to Jamie Lynn.
Okay.
Is there a benefit to filing a direct national application rather than filing under Madrid? Sorry, I misread that. Is there a benefit to filing a direct national application rather than filing under Madrid?
This is a good question. I want to say yes. I think that there are, there are some downsides to the Madrid system. And one of them, of course, is the dependency. So if you are, if you file your home application, let's say you're in the United Kingdom, and then you use that as the basis for your IR, and then your IR gets designated in Canada. Well, if something were to happen to that UK application registration to limit it, or it lapses or it cancels, well, then the same will happen in Canada, and you can revive it. You have to apply to revive it, but there's that risk is still there for this 5-year dependency window. So if you file directly, there's no risk to that. The Madrid process doesn't allow you to have different ownership in different jurisdictions. So for various tax reasons or other legal reasons, companies decide to have different entities own IP rights in different jurisdictions. Well, that's not really possible under the Madrid system. It has to be one owner for the global portfolio. And of course, filing through the Madrid system does not replace the expertise of local counsel. If you want to have certain pre-filing questions about substantive objections which might arise, it's best to speak with a local agent anyway, a Canadian agent, and the Canadian agent can also perhaps give you some advice on how to prepare that application in a way that's most likely to avoid potential obstacles. And so you don't get that expertise and that sort of strategic advice if you file through Madrid rather than directly.
Okay, thanks, Jamie Lynn. Here's another question for you. Now, nobody in Canada will have actually done this before, but here's the question. Jamie Lynn, can you expand upon the merging procedures for two divisional applications?
Certainly, it's simply a request. So you file a request. There's a section of the Act, and the registrar has the power to merge those registrations if they have the same trademark and the same owner.
Okay, thanks, Jamie Lynn. So here's a question. I don't think you'll be able to give a specific answer, but I will direct it to you.
Okay.
So you mentioned that the Trademarks Office is expanding the manual of goods and services to give more examples. And they're going to, I think they're going to emphasize certain classes to begin with, the most popular classes. So here's the question is, what are the top 10 classes of goods and services that will be updated? I suspect you don't know.
I saw the question come in and I just pulled the announcement. So I can answer the question. I have called your bluff. It is classes 3, 5, 9, 16, 25, 30, 35, 36, 41, and 42. I'll see if I can copy and paste these into the chat for everyone in case they're interested.
Okay, good for you, Jamie. Then I wasn't expecting you to be able to answer that. Okay. Okay, this is also directed to you. It's a related question. For applications covering goods and services in the manual, is fast tracking automatic?
Oh, we just discussed this. Philip, I'm going to have to defer to you on this one because I think we were talking about this last week.
Yeah, so the answer is yes. So they are supposed to pick it up. And the question came up. So if you file it new, they're supposed to figure it out, and apparently they can. If you amend your application though prior to examination, and you want to have expedited or faster examination, the question is, will the office know once you've amended it that it complies with the goods and services manual? So they say they're supposed to. They should pick it up, but it's always good to advise them in your application amending, just to say all goods and services are from the goods and services manual. So it doesn't help to remind them. So let's see what else we have here. Okay, this is a complicated question. This is a Jamie Lynn question. So how would a divided Canadian designation work at WIPO? Would it appear as a second Canadian designation under the original international registration? And if you merge them back together in Canada, will WIPO recognize that on the international registration?
So I haven't actually done this, but reading the legislation, what you do is you file the request with CIPO first, and then CIPO presents that request to WIPO, and then WIPO will divide if everything is in order. And it's the same process for the merger. So that's my understanding. Again, not having, I haven't had the opportunity to do this yet on Madrid applications.
Okay, thanks, Jamie Lynn. So this next one's directed to me. What is the policy reason for not sending correspondence to a foreign applicant's representative? I'm not sure. So historically, the Trademarks Office has always only ever corresponded with the applicant or a Canadian agent, and they're simply continuing that procedure. So the Canadian office has never corresponded with a foreign agent or representative. I am not sure what the policy reason is, but it's just simply consistent from what they've done for decades prior to our adoption of Madrid. But I don't have a more enlightened answer than that, unfortunately. Next question. So this is also a correspondence question, which I guess I will answer. How is an applicant notified of a third-party opposition? Through WIPO, through the applicant's representative? Is the applicant notified directly by CIPO? So yes, so I suspect there's a requirement that the correspondence is filed in WIPO, but I'm not entirely sure. I believe that's the case. Jamie Lynn is nodding, but CIPO will always advise the applicant. So if there's no Canadian agent on file, CIPO will advise the applicant directly. And if there is a Canadian agent on file, CIPO will forward the correspondence, the opposition, to the Canadian agent. Okay. Here's a question for Jamie Lynn. This is a good question. If you file with the pre-approved list of goods and services, but if one of the terms is retired at the time of examination, will you receive an objection? Or can you respond by saying that it's in the pre-approved list at the time of filing to get an application allowed? And I'm going to add a subsequent question. What if the term, everything in your application is on the pre-approved list and then it's retired? Do you still get faster examination?
Oh my goodness. Okay. Well, to answer the first question that came in, the ability, so SEPA will only approve an application to be advertised if it meets all of the requirements at the time that it gets advertised, approved. And so if by the time the examination rolls around, SEPA considers that a particular good or service, while previously was sufficiently specific in ordinary commercial terms, is no longer sufficiently specific in ordinary commercial terms, the application is no longer compliant with that section of the Act, and therefore the application can't be approved. So that's an unfortunate situation. Will you no longer be fast-tracked? I don't know what would happen in that case. This is your question.
I thought I would just put you on the spot. I don't know the answer either.
I would assume that it would be yes. You would still be fast-tracked because it was in the pile to begin with as being flagged as being a fully compliant list. And then, but then, do you think it would sneak through? I don't know.
So I agree with you. So I think it should be fast-tracked. I think it would be unfair otherwise. If everything is on the pre-approved list at the time of filing, then it should be fast-tracked, but it cannot be approved because it's not compliant. So I'm guessing that's the answer, but I don't know. So sorry to put you on the spot. So here's a question directed to me, and it relates to inherent distinctiveness. You provided examples of some types of marks for which such an objection would be raised. Are there other types of marks that would raise such an objection? In other words, so I showed you a couple of slides with types of marks where you can be sure to receive an objection that your mark lacks inherent distinctiveness. Are there other types of marks? So yes, anything could, in theory, provoke this objection. But I'll give you one example where we see lots of objections which are not on the list of, not on the lists in the slides that I sent you. What the Trademarks Office now does, I think in virtually every case, is when they look at an application, when they're examining it, they'll Google the mark. And if they Google the mark and they see third parties are using the exact mark in association with overlapping goods and services, they're going to say your mark lacks inherent distinctiveness. Now, this is pushing the boundaries a bit of what inherent distinctiveness means, because in theory, for inherent distinctiveness, it shouldn't matter what other parties are doing, because the objection means inherent in the mark and the goods and services, there's a problem. But they're looking to third parties. And what they're saying is, if third parties are using your exact mark in association with overlapping goods and services, then there's something about the mark where third parties would come up with the same mark on their own. And then it would be unfair to provide a monopoly to one party. The problem, though, that we see is that very often the Trademarks Office doesn't distinguish between Google hits that are Canadian and Google hits are foreign. So sometimes they'll say, well, there are two people in Indonesia using this mark. And usually you can fight back and respond by saying that's not relevant. It doesn't show what the perception would be in Canada. So our view is that if the Trademarks Office is going to rely on their Google searches, they at least have to show some presence in Canada. So next question. So this is for Jamie Lynn. What happens if you file arguments in response to a substantive objection and the examiner maintains the objection, but it is clear the examiner did not understand your arguments? Will you be able to file a further response clarifying your arguments, or will the examiner simply refuse the application at that point?
So that's a good question. If you read the wording of the practice notice seems to leave it open to that possibility, but further guidance that's been provided in discussions with representatives from the Trademarks Office has clarified that, a situation like that where there is a really good faith effort to clarify an argument, that will not be treated with a final refusal. I think the purpose of the final refusal new practice notice is to really address those sort of bad faith or attempts to just lengthen the process and keep the application pending for whatever reason. But a good faith effort to respond to the objection, it really shouldn't receive a final refusal. And we've been told, you'll know if what you've submitted is going to get a final refusal. I don't know if that's the case. I think I would prefer a little bit more certainty from the wording of the practice notice, but the situation that's just been the example provided would be a situation where you shouldn't receive a final refusal.
Yeah, that would be my expectation. We don't have official guidance, but that would make sense. It would be unfair otherwise, I think. So here's a question directed to me. How do I appoint a Canadian trademark agent after we get the IR number? Do we write CPO or do we appoint, or do we do the appointment? Do we write CPO to do the appointment, or should we do it through WIPO? So you write directly to CPO. So it's the same as if it's a directly filed application or a Madrid application. So once the IR number is provided, the Canadian and Canada's Designated Canada will provide a Canadian trademark application number. At that time, you write to the office and you just say, please appoint whomever as agent. Oh, and Canada is quite interesting. We're very trusting. We're a kind and gentle country. You don't need a power of attorney. If you're a Canadian agent, you simply say, please appoint me, and the Trademarks Office trusts you. So I don't think there are many offices in the world that are so trusting. So we have about 4 minutes, and we have currently two more questions. If anyone else has any other questions, please ask them now since we don't have much time, but I'll ask what appear to be our final 2 questions. So this one is directed to me. If you file evidence of secondary meaning to overcome an objection that a mark is not inherently distinctive, how much evidence is necessary? So we get this question all the time. In Canada, I think it's far stricter than other countries. So a couple of points. There are some countries where if you can show use for a particular number of years, such as 5 years, many, or at least some trademark offices will say, okay, you have 5 years of continuous use. We're going to assume that there's secondary meaning. Canada does not work that way. There is no set number of years that will get you over the hurdle. Canada is very strict and requires tremendous, in most cases, evidence of distinctiveness. And you really need to show in most cases that a significant percentage of your target market, and that'll be determined by how you describe your goods and services, a significant percentage of the target market was exposed to the mark prior to the Canadian filing date. So it's a very high bar, and it's hard to achieve. So you really have to show strong presence in Canada. As I mentioned, if you can only show reputation in a few provinces, that's okay. But then your registration will be limited to those provinces. And I think we have one more question. I think this will end it. So this will be Jamie Lynn to end the presentation. Since there is no fee to request expedited prosecution, is there any downside to doing so, even if you're pretty sure you don't meet one of the criteria?
So I think this is the answer. I don't know the answer, but I think my theory is that, you don't want to cry wolf, as the old parable goes. So there used to be an expedited examination procedure in Canada. From what I understand, that process was abused, and it took examiners a lot of time to consider these baseless requests, and so they got rid of it. So I suspect that, if we have a lot of applicants filing these baseless requests for expedited examination, that we might all lose the benefit of it in the future. So it's more of a, we got to work together to, not lose this good thing that we've just received.
Okay, thanks, Jamie Lynn, for ending our presentation. And I would like to thank everybody for joining us today, spending part of your day, and for asking all the great questions. It really means a lot to us that you're interested and that you've spent the time asking us questions. So on behalf of Jamie Lynn, thanks very much for watching, and stay tuned. Next month, we will have another webinar. Have a good day, everyone. Bye.